Actually, Doctor, this program also is broadcasted live on YouTube. So some of the participants from our side is actually joining from in YouTube.
Yes.
Live on YouTube, yes.
Yeah, I got it. Yeah, I got it.
So, Mizan, do you have any number from, I suppose, partly from Ankara, students from Ankara?
The one who registered through the Google form that we distributed earlier.
Live on YouTube. So some of the participants from our side is actually joining from
Okay, we are live on YouTube, yeah? We are live on YouTube. So whatever we say after this will be recorded in YouTube.
As of yesterday, I think more than 50 from Ankara who
More than
registered.
50.
Yeah.
Just a minute. Just.
Farid, nice seeing you again online, even though it's only online.
For your information, Doctor, we have 114 registered participants from your university.
I'm so sorry again. Our rector cannot connect because of a internet connection, but our vice rector, Professor Jawahid, will participate the connection in a few minutes. Vice rector Professor Jawahir will participate in a few minutes in this activity. I think our rector has an internet connection problem. That's why they say me that they are so sorry about this situation.
Okay.
A minute. Ama bu şifreye girebilir miyim ki?
Okay, Assalamualaikum warahmatullahi wabarakatuh. Ladies and gentlemen, distinguished professors, as we are waiting for the Vice Rector to join us, allow me to just do a few housekeeping just before we start our seminar tonight. For the students from IIUM, you may later on fill out your attendance using the I attend link that will be shared in the chat box. And those who are watching us from the YouTube, it will be shared in the comment section. And for the participants later on who would like to ask questions, please post the questions in the Q&A box. Instead of chat box, please post your questions in the Q&A section.
Yes.
Okay, I think we can begin our webinar tonight, yeah, Dr. Ahmad? All right.
Yes, please. We can start. I think we have another internet connection problem about participating in this activity.
Okay. Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and a very good evening I bid to everyone in the Zoom as well as those who are watching in the YouTube. I guess it's afternoon there in Ankara right now. It's 3 o'clock, I was made to understand.
Yes.
Okay, distinguished professors, academic members, ladies and gentlemen, brothers and sisters, it is my pleasure to be the moderator for tonight's webinar. And our webinar tonight is on the era of Uthmaniyyah and its contribution towards the development of Islamic law. And we are honored to have with us tonight the Honorable Professor Emeritus Tan Sri Dato Zulkifli Abdul Razak, the Rector of IIUM, International Islamic University, Malaysia. The Honorable Dean of Faculty of Law, Ankara Yildirim Beyazit University, Professor Dr. Hairi Bozjik. Distinguished speakers, Associate Professor Dr. Ahmed Kilinc, Professor Dr. Farid Sufian Shuaib, Dean Ahmad Ibrahim Kulliyyah of Laws, the Honorable Dean of Center for Foundation Studies, Brother Murshid bin Qasim, distinguished academic members from Ankara Yildirim Beyazit University and IIUM, and students from both institutions. Welcome to our first international webinar. Inshallah, tonight we will be listening to a very interesting topics that will be delivered by both Dr. Ahmed as well as Prof. Dr. Farid Sufian, who will be talking on the development of fiqh during the Ottoman and the Reformers, as well as the application of the Ottoman Reformation, the Majallah, in the Malay Archipelago. But before that, my name is Mizan binti Muhammad. I'll be your moderator tonight. And we will start with some welcoming speech from our distinguished guest. And without further ado, I would like to invite Tan Sri Professor Dato' Zulkifli Abdul Razak, our rector of the International Islamic University, Malaysia, to deliver his welcoming speech. Please welcome.
Thank you very much, Sister Mizan. Bismillahirrahmanirrahim. Alhamdulillahirabbil alamin wassalatu wassalamu syafil anbiya mursalin wa ala alihi wa sahbihi ajmain la haula wala quwwata illa billah. Assalamualaikum warahmatullahi taala wabarakatuh. Especially to all of you, and namely Honorable Professor Ibrahim Aidinli, Rector of Ankara Yildirim Beyazit University, Honorable Professor Hairi, Dean Faculty of Law, and also Associate Professor Ahmad, Kilinc, and also my colleague, Professor Farid Sufian, Brother Murshid Qasim, distinguished brothers and sisters from both university. Indeed, praise to Allah Ta'ala for giving us this opportunity to meet on this platform on a very, very important topic of understanding the era of Uthmaniyyah and its contribution to the development of Islamic law. Certainly, this part of the world, Malaysia in particular, have benefited a lot from this. I want to congratulate both institutions for thinking along this line so that relationship between two universities and in fact two countries will be further strengthened in this era of the pandemic that looks at how we can live together in harmony between two communities for the sake of humanity. And certainly in this particular context, the legal dimension in whatever perspective you look at becomes an important sort of issue that needs to be dealt with and understood by everybody, not only us in the university, but also the people on the ground. And therefore, this discussion, the way you started today, I hope has got a very good scope of us trying to build up this relationship between two countries, and certainly beyond that into Rahmatan lil Alamin. Mentioned earlier, I'm not a legal person, but I do understand that Ottoman Empire contributed tremendously. I remember when I was in Istanbul in the year 2015 to receive this honorary doctorate from Islamic Commerce University. We were brought to certain places. I still remember very vividly the role of Sultan Fitr, I think, that saved the Ottoman Empire and in fact vanquished the enemies in trying to build up another civilization in that part of the world. These are issues that I think which is important for the younger generation who are probably out of touch of history in many cases because of the kind of lifestyle that we have adopted. And therefore, discussion of this nature makes us remember what the contributions are and what the contributions that need to be made as we move forward, particularly from the Islamic perspective. My university, the International Islamic University, works very hard on this in trying to develop another platform where Muslims in particular can play a very distinguished role in a lot of global situation, global agenda. As it stands now, for example, when you talk about global warming, climate change, the COP meeting in Glasgow that's coming on, how do we Muslims contribute to this so that we are seen as partners in development as far as the world is concerned, not just a bystander or not just a recipient of somebody else's knowledge and somebody else's goodwill. We as a Muslim has a lot of work to do and have to give many suggestions so that the world can be a better place. And this is what we believe in university. And I hope our relationship with your university can also reinforce this kind of an effort together. So I will not take a lot more of your time. There's 176 participants now eagerly waiting to hear what the discussion is all about. I was hoping that I can listen to you as well, but I need to take a short break away because there's another webinar that's going on, I think at about 8:30, but I will join you shortly the moment that is finished. So congratulations once again, all the best, and we pray to Allah subhanahu wa ta'ala that we are given all the blessings that this webinar will bring us to new lights, new horizon, so that we can work together very much closely in whatever endeavor that we decided to take tonight, insyaAllah. So wabillahi taufiq wa hidayah, wassalamualaikum warahmatullahi ta'ala wabarakatuh. Have a good deliberation and discussion. Assalamualaikum.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much, Tan Sri, for that welcoming speech. Now, to continue our webinar tonight, I would like to cordially invite the Dean, Faculty of Law, Ankara Yildirim Beyazit University, the Honorable Professor Dr. Hairi Bozcik. I hope I pronounced the names correctly. Please welcome Professor Hairi.
I think you are muted, Mr. Dean.
Okay. Thank you very much. It was correct. Not anything. There's not any problem. Dear rectors, dear colleagues, and dear students, the two countries, Malaysia and Turkey, are two states that have a lot in common. As people living in two countries, we have more in common. Both sides are trying to build a better legal system for their members. For a good cooperation, we need to create a new meeting grounds and take small steps. In this process, law faculties or faculties have serious duties and responsibilities. We attach importance to cooperation in all fields related to legal education. I'd like to thank Professor Farid Sufian and Professor Ahmet Kilinc, who brought us together today, and all our students who participated in this course, and our rectors who supported for this event. I hope that this study will create a meeting ground between two students and academicians of our faculties and lead to new joint studies. Thank you very much.
Thank you, Professor Hairi, for that brief and sweet speech. Now, before we start with our webinar tonight, I shall now welcome the Honorable Professor Ibrahim Aydinli, the Rector of Ankara Yildirim Beyazit University, to deliver his welcoming speech. Please welcome. Professor, are you there? Is there by any chance Prof. Ibrahim? I could see that Prof. Ibrahim is on the line with us. Or shall it, Prof. Ahmed, Probably we could say. Okay, maybe Professor Ibrahim will be joining us shortly. There seems to be a slight technical issue, but we have now come to the highlight of our webinar tonight, in which we will have our distinguished speakers delivering a talk on a very interesting topic. First, it will be delivered by the Honorable Associate Professor Dr. Ahmad Kilinc on the topic development of fiqh during the Ottoman and the Reformers period. Just before we start, a little bit about Dr. Ahmed. He obtained his doctoral degree in public law from Ghazi University. And previously, he held the position as Vice Dean at the Faculty of Law in Ankara Yildirim Beyazit University. And he has been actively involved in writing papers, presenting in international conferences and seminars. So, Professor Ahmed, the floor is yours.
Okay, thank you very much. Assalamu alaikum wa rahmatullah. My esteemed rectors, my dear deans, distinguished academics and students, I would like to thank Professor Farid Sufian bin Shuaib for giving me a chance together with him and his excellent students. I am honored. Also, International Islamic University of Malaysia made a great effort for this webinar. I also want to thank the staff of International Islamic University of Malaysia and Ankara Yildirim Beyazit University and their hardworking staffs. So let me start my presentation. My topic is the development of fiqh in the Ottoman state. Next slide, please. As it is known, the history of Islamic law is divided into 6 periods in chronological terms. And these are, as seen on the screen, the first one is the period of Prophet Muhammad sallallahu alaihi wasallam, and the second one is the period of 4 caliphs and companions, we can say Sahaba. And the third one is the period of the Tabi'in. And the fourth one is the formation of the sects or mazhabs. And the fifth one, one of the important one is the period of taqlid or imitation. And the last one and the sixth one is the period of codification and new ijtihad. Next slide, please. The Ottoman state includes the period of imitation and the period of codification and new ijtihad. Today, it should be said that we are still in the last period. For this reason, it is useful to remember the basic information about the 5th and 6th periods. Later on, I will give information about Ottoman practice in these periods. Next, please. Let me give information about taqlid period or imitation period. The period is between the middle of Hijri 4th to the end of 13th century. The period was called the period of imitation or taqlid. The distinctive feature of the legal activities in this period was not to produce new solutions to legal problems with ijtihad and to develop the law, but to expand the interpretations of fiqh mazhabs that emerged in the previous period and make them more understandable. In the period of imitation or taqlid, the studies of Islamic jurists was entirely within the boundaries drawn by the 4 legal sects or mazhabs. Islamic lawyers wrote doctrinal studies in the form of annotations, we say it Sharh in Turkish, in accordance with the rules and principles that Mazhab Imams had preached. Thus, in this period, valuable legal corpus emerged. In the period, studies on Islamic law have emerged in the form of texts, commentary, annotations, and fatwa books. The period of Taqlid chronologically corresponds to the 13th century and the beginning of the 19th century, which we define as the classical period of Ottoman state. In order to understand the developments in fiqh in Ottoman classical period, we need to explain the Ottoman legal system. Next slide, please. The Ottoman legal system in the period of imitation or Taqlid consists of two main parts. One of them is Islamic law and the other is customary or Sultanic law. In Turkish, we say it Örfi law. Next slide, please. In the Ottoman state, Islamic law was applied both theoretically and practically during the period of Taqlid. In the practice and theory of law, four primary, Quran, Sunnah, Ijma, and Qiyas, and secondary sources have been abundantly utilized. There are many fiqh books written in this period. As it is known, fiqh books are studies that explain the legal topics and institutions and their sources, sometimes deal with the subject comparatively between the mazhabs and reach a preferential result by discussing different views on controversial issues. So let me introduce one of the fiqh books which was used as a course book in madrasa in the Ottoman state in the 17th century. Ibrahim Halabi's Multaqal Apur, which is the main reference book of the judges in the religious courts after the middle of the century, is a study in this group. As has just been stated, many fatwa books were published in this period. Fatwa books are works or studies that bring together the answers given to the questions people ask about legal issues they face in daily life. Ottoman judges or qadis frequently applied to fatwa books. The fatwas of Abu Suud, Fatwa-i Fevziye, Fatwa-i Ali Efendi, and Fatwa-i Yahya Efendi drew attention as the studies that qadis most frequently used. Monographic studies or works. There are studies or works that deal with a legal issue, examine it in detail according to the various possibilities, and reach a conclusion. For an example, many monographic studies, risales, were written about the cash money foundation, which caused great controversy in Ottoman state. There are also famous personalities such as Abu Suud Birgivi among the owner of the treaties. It is possible to see references to the main sources of Islamic law, Quran and Sunnah, in the Qadi registers. Next slide, please. You may see the Ibrahim Halabi's Multaqal Apur, a page of Multaqal Apur. Next slide, please. And I also want to show you the another fatwa book, Netijatul Fatawa, which was written by Shaykhul Islam Durizadeh Mehmet Arif. Next slide, please. And this is another risale, which was written in this period by Muhammad Pir Ali al-Birgiwi. Next slide, please. So, of course, it is possible to see some differences or riches unique to the Ottoman state in this period. We can say there are three different features in the Ottoman state. The first one is official mazhab preference. Second one is Sultanic law or customary law. And the third one is status of Shaykhul Islam. Next slide, please. Thank you. Theoretically, the first of these differences is the official sect or mazhab preference or practice. As it is known, there can be more than one ijtihad on a subject in Islamic law. These ijtihads can also contradict each other. In this case, it should be determined which ijtihad the judge should choose while he was solving the problem. Since the middle of the 16th century, the Ottoman state wanted the dispute to be resolved according to the Hanifi mazhab's ijtihad. For this reason, it was clearly stated in the letters patent for the appointment of judges or qadis and muftis that the decision and the fatwa would be given according to the Hanifi school. And it was forbidden to make judgment in line with ijtihad of any mazhab other than Hanifi school. This understanding was also reflected in the court records. For example, judges decides according to the Imam Muhammad and Abu Yusuf's ijtihads, who are the students of Imam Azam Abu Hanifa, about cash foundations. Next slide, please. Thank you. Another feature that distinguishes the Ottoman state in this period is the existence of Sultanic law. It is because many branches of law have been formed with Sultanic law rules. So what is Sultanic law or what is customary law? There are too many definitions about Sultanic law. It can be summarized as Sultanic law is the law created by political authority of the time, we say it Ulul Amr of Islamic State, within the limits set by Islamic law. The main authority here in Sultanic law is the political authority of time. The Sultanic law shows itself through kanuns or kanunnames. The kanunnames are discussed in Diwan-i Humayun, which means Sultan's board, made up of senior executives, and are announced with Sultan's edict. Shaykhul Islams of the period also supported the development of Sultanic law. For an example, Shaykhul Islam Pir Mehmet Efendi, who was dead on 1620, gave the following answer to a question asked to him. It is necessary to apply to the political authority in this matter. The rule is established as or how the political authority orders. It is obligatory or wajib to obey the political authority for public order. In the Ottoman state, administrative, financial, military, tax regulations, land law, ta'zir crimes, and penalties were mainly codified with Sultanic law. Of course, Sharia law and Sultanic law are not separated from each other with certain lines. Sharia and Sultanic law rules are placed side by side. Next slide, please. Another feature that makes the Ottoman state different is the status of Shaykhul Islam. As a matter of fact, the Shaykhul Islam had extensive powers in the legislative, administrative, and judicial topics in the Ottoman state during this period. Shaykhul Islam's opinion was taken before the laws were enacted. At the beginning of the Kanunnames, there is a provision that means it is the Sultan's code that was prepared in accordance with Islamic law. When important administrative decisions were to be taken, Shaykhul Islam was called to the Divan or Sultan's board and asked for his opinion. Even the Sultans themselves received a fatwa from Shaykhul Islam. And also they had the power to choose and offer qadis to Sultan. Therefore, Shaykhul Islam has ceased to be an institution that not only transmits the theoretical knowledge, but also has an active role in state administration. Next slide, please. You can see a Qadi and Shaykhul Islam. Next slide, please. And the period that we are living in it, the period of codification and the new ijtihad. The period we are in terms of Islamic legal history is the period of codification and new ijtihad. Within the framework of the limited legislative authority granted to the Ulul Amr by Islamic law, modern legislation movements were seen in the Ottoman state, especially after the Tanzimat edict. The first step in this regard was the preparation of Majallah-i Ahkam Adliye. This was followed by the Law of Family Decree of 1917. After the 1920s, codification movements in the family and inheritance law started in other Islamic countries as well. In this period, both Islamic law was put into practice in accordance with the modern codification technique, and mazhab fanaticism was overcome. And not only one mazhab, but also the legal views of other mazhab was utilized. Thus, the period of taqlid and the following only one mazhab has ended. As a result, a suitable ground has been prepared for the initiation of jurisprudence activities in Islamic countries to adapt Islamic law to the needs of the day. In this period, codification movements in the Ottoman state accelerated. Next slide, please. You can easily see the Majallah-i Ahkam Adliye in Ottoman language or Turkish language in Arabic alphabets. Next slide, please. So let's talk about the reasons for the legislation movements. The first of the reasons for legislation movements of the Tanzimat period is the change in commercial, economical, and social life. Change in social life, especially the change in the roles of women in society, are among the reasons for enactment movements. Legal needs also led to the need for new laws. As a matter of fact, the effects and pressure of Western states are also among the reasons for enactment movements. In the preparation of new laws, different opinions declared in Ottoman state in this period. Some views suggested that Islamic law should be codified in a modern way. Some other opinions recommended that Western laws should be transferred to the Ottoman state. As a result, there has been a dual distinction between domestic or national laws and the laws taken from the foreign legislation by way of quotation or reception. Next slide, please. In the Tanzimat period, the domestic laws prepared without benefiting from the laws of foreign countries are the penal laws of 1840 and 1851, and the Land Code of 1858 and Majalla, which was completed between 1869 and 1876, and the Family Law Decree of 1970. In the Family Decree of 1970, the Ijtihad of Hanifi Mazhab, which was the first official Mazhab, was abandoned on some issues. And the views of other legal sects or Mazhabs, Maliki, Shafi, Hanbali, was preferred, and solutions were tried to produce for social needs and conditions of the age without going beyond the limits of Islamic law. The laws prepared by making use of the laws of other countries are the Commercial Code of 1850, the Criminal Code of 1858, the Commercial Procedure Code of 1861, the Maritime Commercial Code of 1863, and the Criminal Procedure Code of 1879, and the Civil Procedure Code of 1879. The codification movements in the Tanzimat period created a dualist structure in the Ottoman legal system. While the rules of Islamic law remained varied, and laws taken from the Western countries were tried to be implemented in certain areas. This dualistic structure has led to a serious problems. Next slide, please. Yes, conclusion. As a conclusion, what can we say about this we are talking about? The Ottoman state has a very important experience in terms of Islamic legal history. Very important studies emerged during Taqlid period in Ottoman state. And Ottoman state started the beginning of the new Ijtihad period, which we live in. The laws enacted in the Ottoman state were implemented even after Ottoman state was overthrown. And the laws enacted in the Ottoman state set a precedent for many Islamic countries. Next slide, please. I think these are the things that I want to share with you. I would like to thank you again, and if I am not wrong, I hope it is not wrong. Terima kasih. Thank you very much. Thank you very much.
Teşekkür ederim. In Turkish language, I believe. I was in Antalya back in 2010, so I pick up the teşekkür ederim from the locals there. Thank you so much.
Thank you very much, Mrs. Mizan. Our Vice Rector, Professor Javit, also participated to our activity.
Yeah, welcome, Professor Javit.
Yes.
To our webinar. Thank you so much for joining us. I hope you are doing well over there.
Thank you very much. Dear colleagues and participants, I am attending this meeting on behalf of our rector, Professor Dr. Ibrahim Aydınlı. Actually had an emergency meeting. It was sudden for us. He informed me on that, give his apologies, and I would like to convey his greetings to you. My name is Cevahir, not Javit, Cevahir Uskurt. I am Deputy Rector at Ankara Yildirim Beyazit University. I would like to thank the organizer of this meeting. Actually, the meeting topics is very interesting and very important for us. This presentation benefited for us. I believe that the meeting's consequence will be beneficial for us, like the other colleagues. Again, I would like to thank you, all of you. I am very delightful participating in this meeting. Thank you very much.
Thank you so much, Professor. So just now in the presentation given by Dr. Ahmed, he talked about a very important document called the Majallah. That has become one of the main reference when it comes to Islamic law back then in the era of Uthmaniyyah. So before we move on to the question and answer sessions, I would like to invite first Professor Dr. Farid Sufian, Shuaib, who will be speaking to us on the application of the Ottoman Reformation, the Majallah, in the Malay Archipelago. So the Malay Archipelago basically refers to the areas within the Southeast Asia, basically covered that area. So we're going to look at how this Majallah has influenced the development of Islamic law within this region. Without further ado, I would like to welcome Professor Dr. Farid Sufian, currently the Dean of Ahmad Ibrahim Kulliyyah of Laws. Just a little bit about Dr. Farid, Prof. Farid. He obtained his PhD from the International Islamic University, Malaysia, and among the areas of specialization of Prof. Farid is, of course, the administration of Islamic law, constitutional law, as well as multimedia law. So without further ado, I would like to welcome Prof. Farid, and the floor is yours.
Thank you. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. First, I would like to thank Sister Miza Muhammad from the Center of Foundation Studies, International Islamic University Malaysia, with the support of Tuan Haji Murshid, the Dean of the Center for Foundation Studies, International Islamic University Malaysia, for initiating this program, because this program originated from a program meant for the student for Center for Foundation Studies, IIUM. And of course, I would like to thank Associate Professor Dr. Ahmad Kilinc, my good friend, with the support of Prof. Dr. Hairi Bosgani, the Dean of Faculty of Law of Ankara Yildirim Beyazit University, and of course, Professor Jawahir, the Vice Chancellor, for supporting the idea to collaborate together in combining our contribution for both of our students and also for others who are interested in this topic, to discuss, I suppose, as mentioned by Tan Sri Rector, Professor Emeritus Dr. Zulkifli Razak, an important issue for us to discuss and for us to also convey to our students and all those who are interested in the contribution of Ottoman in the civilization. I think Dr. Ahmed Kilinc have amply and ably explained to us the development of the Ottoman law. If I may first share this my slide. Okay, is it okay? I hope all of you can see the slide.
Yes, we can.
Okay, good. Let me just okay. So Dr. Ahmed Kilinc have talked about the development of the Ottoman law, and as Sister Mizan have mentioned, that I want to just to connect what Dr. Ahmed Kilinc have discussed with the Malay Archipelago, or in particular Malaya or Malaysia that we know of. But first, for the benefits of our colleagues, the Vice Chancellor of Ankara Yildirim Beyazit University, and our students, beloved students from Ankara Yildirim Beyazit University. First, probably just let me explain a bit about Malaysia. Probably, I hope all of them knows about Malaysia, but I just want to add to their knowledge if they have been exposed to Malaysia. So this is our university, International Islamic University Malaysia, and I also share the image of our Kulliyyah, Ahmad Ibrahim Kulliyyah of Laws. Only half of the building is Ahmad Ibrahim Kulliyyah of Laws, the other half is the Kulliyyah of Economic and Management Sciences. And then what Sister Mizan mentioned just now about Malay Archipelago, we have, if you probably is too small, but generally this is Malaysia, this area is Indonesia now, and you have the Thailand, Cambodia, Philippines. So this is generally the area of Malay Archipelago. That what we refer to as the Malay Archipelago, which contains islands, basically maritime nations and so on. And this is what the states of Malaysia that we have. One is the left side of it is the Malay Peninsula, where you have all the states. Kuala Lumpur would be around here. You have on the north, in the north is Thailand, in the south is Singapore, and this is just part of Malaysia. From the island of Borneo, we have Sabah and Sarawak. So with these two, the West Malaysia and the East Malaysia, you have states of Malaysia, the 13 states of Malaysia. Okay, regarding the demography, just briefly, that we have about 30 million plus population with multi-ethnic and multi-religious groups. We have what referred to as Bumiputra, about 70%. We have the Chinese, Indians, and the indigenous groups, ethnic groups in Sabah and Sarawak. It is multi-religious with Muslim 61%. We have Buddhism, Christianity, and Hinduism. So that's generally the demography of Malaysia. I suppose quite different from Turkey, which if not 100%, 90% plus is from Muslims population. Before I go to Malaysia, just again to relate to what we have what was discussed by Dr. Ahmet Kilinc, that we have this long relationship between the Ottoman and the Malay Archipelago. One example would be the relationship between the Sultanate of Aceh with having a relationship with the Ottoman since the 16th century. Among others, the Sultanate of Aceh had requested the assistance from the Ottoman for them to fight against the Portuguese when Portuguese were there in, for those from Malaysia, you remember about the Sultanate of Malacca, the Portuguese taking over Malacca, then the Dutch, and so on. So during that time, of course, Aceh is on the northern tip of Sumatra. They also were threatened by these colonial powers, so they have sought assistance from the Ottoman, and the Ottoman did send assistance to them, send ships, send weapons to assist them in their fights against the Portuguese, among others. And the other probably relationship that I could highlight here, even in Philippines, there is also a relationship between the Ottoman and the Philippines, in particular about the Muslims in Mindanao, where some of the leaders of the Muslims, referred to as the Moro Muslims, had addressed a letter to the Ottoman in the 20th century, writing to the Ottoman to seek their assistance. And this time, the Ottoman did send an officer, religious officer, and in one meeting he was regarded as the Ottoman Sheikhul Islam of the Malay world. I suppose the details you can refer, for instance, in the website of the Center for Ottoman and Malay World Studies. And this is what I want to highlight here is the relationship between the Malay Archipelago with the Ottoman. So the Ottoman and the Malay Archipelago is not strangers. We have relationship with Turkey, for instance. Now, it's not only now that it's happened. It's not only in this century that it happened. We have that relationship even in the 6th century during the Ottoman period. Okay, so I think this would be the area of Dr. Ahmed Kilinc. I will not try to replace him to explain what Majalah Ahkam Adli, where he mentioned that it was completed in 1876. If you refer to the Majalah, you have description on the sources of law, on the principle of contract, on the principle of procedural law, on the principle of evidence in the Majalah. And also Dr. Ahmed Kilinc have explained about the process of Tanzimat, or among others, the process of codification of the laws in a way to modernize the fiqh in the sense of putting it in systematic erudition. So this what we have, what Dr. Ahmed Kilinc have discussed previously. So then we want to connect this. What I have done before this is to look at the use of the Majalah, not about the history, but the use of Majalah at present in Malaysia. So this I hope will be something interesting also. This is where I have met Dr. Ahmed Kilinc when I presented this paper. He would be the one on the experts on Majalah. I'm just connecting the Majalah with the Islamic finance, the use of the Majalah or the reference to Majalah Islamic finance in Malaysia, which I think, if I may say, would be an interesting finding. So in doing that research, I found this connection with Johor, connection between the Majalah and Johor, and this is something I tried to go further in exploring that connection. So again, for the benefit of our students or participants from Turkey who are not familiar with Malaysia, in Malaysia, just briefly on the early history, you have a gradual process of Islamization. There is convergence of influence in Malaysia. You have early on the influence of Hinduism, Buddhism. Then you have the Islamization process in Malaysia, where the teaching of Islam arrived in Malaysia, and this has been adopted by the Sultanates, the Malay Sultanates, and from Maharaja they become sultans, taking into the terminology and the labeling from Islamic teaching. This happened in well, there are different views, but I suppose we could take it that Islam arrived in Malaya in 14th century. You have examples, I suppose, for those from students from Center for Financial Studies have discussed this about the early codification that we have found in Malaysia on Hukum Kanun Melaka, the Pahang laws, the Perak laws, and so on. So that's briefly on the connection between Islam and Malaya or Malaysia. So similarly, Johor as a state or as a sultanate, one of the Johor Sultanate will be one of the sultanates before the creation of the nation state of Federation of Malaya and then Malaysia. We have the Sultanate of Johor, where you have the application of Islamic law and also the application of customs, where there is instances of prosecution is made based on Islamic law and custom, and then you have the engagement with the British. You have in a way, modernization of the state of Johor, where there is setting up the state council, state departments, judicial and police departments, and so on, as the machinery of the government. And then you have the engagement between the Sultan of Johor and the British, where they arrive into a treaty, and then Johor have the state constitution, spelling out the general principle of the state. And as an example, you have the penal code in 1908, and then you have the application of the Majallah in 1913. So that's just a brief picture on Islam, the connection between Islam and Johor, and the development of the state, and then you have the application of Majallah Ahkam Johor, which is basically referring to the Majallah as described by Dr. Ahmed Kilinc, but translated into Malay. So what's the story behind this? So the story behind this is that the Sultan, or specifically referring to as the Temenggung, Abu Bakar, as the Sultan of Johor, have visited the Ottoman in the 19th century, and have observed, I suppose, the development, the transformation of the Ottoman, and also have taken into account the dressing, the design of the building in Turkey. And there is this relationship between the Ottoman and the Sultanate of Johor, which in a way, I suppose, influence the Johor Sultanate. So you can see, for instance, the design of the Sultan Abu Bakar Mosque in Johor, which arguably could be said to be influenced by, probably most of the students will be familiar with the Blue Mosque and so on. And so you have in 1913 the translation of Majallah Ahkam Johor, and stated in preamble for the Majallah Ahkam Johor to be applied by the magistrates, the judges in Johor, to apply the Majallah in relation to Islamic law. And I'm at the end of my time. So what I would say, first, of course, it will be interesting to do a more detailed research on we have the pronouncement in 1913 on the application of Majallah Ahkam Johor, or in other words, the Majallah, but to what extent that it was applied. One, of course, another general question that we want to consider is the significance of the relationship between the Ottoman and Malay Archipelago, in particular in Malaya. Certainly, what I hope to establish is that we have that relationship. And then, of course, a more general question would be how we could further strengthen the relationship between now Turkey, because we don't have the Ottoman Caliphate anymore, between Turkey and the Malay Archipelago, and in Malaysia in particular. And to adopt what Tan Sri Zulkifli Razak mentioned about how we could forge a better relationship in order to have a better world for the benefit of everyone. With that, thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much, Prof. Farid. It's very enlightening to see how the 600 years history of Uthmaniyyah has actually influenced the other part of the world, particularly those in the Southeast Asia. And of course, I think the spillover effect of the empire has to a certain extent impacted many countries in terms of the development of Islamic law. Now, to continue our webinar tonight, we have a lot of questions coming in from the participants in the Zoom, and inshallah, there will also be a question that will be asked live by the audience who requested to ask directly to the speaker. But before that, allow me to read the first question that came in. This question, I believe, is directed to Dr. Ahmad. After the Tanzimat, is there any action taken by Usmani Sarai or Shaykhul Islam at that time to block Western influence in Osmani Devleti and to implement Sulaiman Qanuni in a very strict way?
Assalamu alaikum again. Thank you very much. Bismillahirrahmanirrahim. Yes, thank you very much for question, Mohammed Harun Nas. Yeah, this question is important. Yes, we can say that our student wants to understand, is there any action to prevent the Western influence? We can easily say that yes, there is an action to trying to prevent the Western influence. But it is, can we say that it is successful? Not yes or not no. What I mean, it is successful because we have seen Majalla, because Majalla is enacted directly according to the Islamic law. But while we have Majalla, we also have another Western law codes. So that's why I'm saying that there are dual legal system. In that time, we have both Western laws, and also we have national laws or Islamic laws. So that yes, we can say that there is an action. The significant example of this action is we can say that Majalla, or we can say that Family Law Act 1970. I think it will be enough. And
okay, moving on, there's also another question regarding Shaykhul Islam, which Dr. Ahmad, maybe you can explain, because it's from an anonymous attendee. Maybe you can explain a little bit more on Shaykh al-Islam, on his background, and why is his opinion considered important?
yes, important. Yeah, Shaykhul Islam is important in Ottoman state. Why I am saying it? Because Shaykhul Islam has the authority. He has not only the, he has a scholar, you know, he's a scholar who knows Islamic law in deep or in detail. And he will, in normalize, he will just give an fatwa. But in Ottoman state, he has some legislative authority or some administrative authority or legal authority. Let me give an example. For example, in Ottoman state, in the classical period, Shaykh al-Islam has the authority to choose the judges, and sometimes he was making an examination for judge syndicated, and he made the examination and he offers the names to the Sultan to be a judge. So we can easily say that he has the authority in legal issues, and not only in the legal topics. He has the authority in administrative issues, or he has the authority in legislative issues. So we can easily say that he is a little bit more important in Ottoman state when we compare with the other Shaykh al-Islam in Islamic legal history.
Okay. Next question from a student Salim Zaibek. He asked, are regulation issues of customary law, Sultani, and Sharia distinguished from each other, or are there contradictions?
Yeah, are there contradictions? It's a very hard question. We can say that it's a very hard question. It's not so easy to answer this question. Why am I saying that? Theoretically, Sultanic law cannot be contrary to Islamic law. But I'm saying it in theoretically. In theoretically, Sultanic law cannot be contrary to Islamic law. But we have to understand, or we have to look at the practice. We have to look at the practice. So how Ottoman state used Sultanic law with Islamic law. I think we cannot generalize it. We cannot easily say that yes, or Sultanic law can be contrary to Islamic law. We cannot say that. We cannot say it in general way. In my opinion, we have to evaluate or discuss or argue each event or each law specifically. We cannot easily say that generally, yes, Sultanic law cannot contrary to Islamic law. Or we cannot say, we cannot have to, we shouldn't make a general opinion.
Okay, all right. Thank you, Doctor. There is a question regarding coming from our brother Wafi. He asked, I think this is our student from IIUM. He asked, does Turkish legal system nowadays still apply the Sultan legal system?
Yes, the custom legal system. Yes, according to our constitution, which was dated in 1982, you know, Turkey is a secular state, so we cannot say that Sultan's I cannot say that Sultan law is applying in Turkey just now.
All right. Another question is regarding the application of Mazhab Hanafi. As of today, are the courts in Turkey still apply only Mazhab Hanafi when resolving dispute as what was practice, or has there been any new approach?
Yeah, I think this question is about in the current issues, right? Yes, and if I don't understand correctly, the questions is about is it in Turkish courts Hanafi mezhab is implemented or used still? I think it's the question. Yeah, I have to say the same answer. As a secular state, we cannot easily say that Hanafi mezhab or other mezhabs are the source of law in Turkey now. They are not the source of law in our country currently.
Okay. Another question. This is regarding the taqlid period. Okay, it's also from an anonymous attendee. From your opinion, did the period of taqlid tremendously caused the Islamic law to become stagnant during the period of Uthmaniyyah?
Yes. Actually, for my opinion, I don't want to say that Islamic law stopped its development. We cannot say that the development of Islamic law ended in the taqlid period. We cannot say it. Why? As I, in my presentation, as I want to try to explain, there are many famous fatwa books, fiqh books, and there are lots of Islamic sources in that period. And the sources that I showed in my presentations are all of them were written in the Ottoman state in the classical period. But the understanding of Islamic law has changed in that period. Just I want to mention about this issue. But we cannot say the development has been ended. No, there is no. The development is going on, but the methodology has been changed in that period.
Okay. There is another question regarding the Majallah. I know Shazwina asked, since the Majallah mention favors the views of Hanafi, is there any other views from other sect in it?
Yeah, in Majallah, right?
Yeah. And so in the Majallah, was there any other views other than Hanafis? And the codification version is flexible.
Yeah. Yeah, this question is very important in accordance with the Turkish history law. There is a certain answer of this question. Yeah, Majallah has enacted according only to the Hanafi mezhab. There is no other mezhab ijtihads in Majallah. Yeah.
Wonderful.
This was an easy question for me.
Okay, maybe for this question, both Dr. Ahmad as well as Prof. Farid can answer this question. It asks, there are a lot of questions actually regarding the Majallah. Is the content of Majallah still applicable in Turkish law now?
Yes, yeah, probably the answer is the same. In the content of Majallah is not still usable in Turkey just now. The judges in Turkey cannot reference to Majallah.
I see. Okay, there's this one question from Auni Farhatain. There are two questions that she asked. Can you explain more example about Maritime Commercial Code?
Yes, yes.
And can you explain more about the problem with dualistic system mentioned in your presentation?
Yeah, thank you very much. Maritime Commercial Code, yeah, we can easily say that this Maritime Commercial Law has been enacted from Western countries. We can easily say that, if I am not wrong, this commercial code has been transferred from France Commercial Code, and the situation, the methodology are all gained from the Western countries. It has so many details actually. Maybe I think we don't have time to explain the details, but I can easily say that it is not a national law rule. And what was the other question? I cannot see the other question. I think he or she asked another question about a dualistic question. Yeah. How was the problem? Yeah. In Tanzimat era, as I said before, there are a dualistic system in Ottoman legal system. What does dualistic system means? It means that there are two judges, and both two judges has different law sources. And when we have one problem, a legal problem, this one problem could be solved in both in Sharia law and in both in Nizamiya courts and on the Western courts. So it makes a problem. We can easily say, and our archival records shows us that there are so many problems on this issue. For example, and we can easily say so many legal issues has a problem in this situation. We think about it. There is you have a legal problem, but you don't know which court you should apply. Should you apply to Sharia law or you should apply to Nizamiye courts? So it is important because if you apply to Nizamiye courts, it will use another law sources. If you apply to Sharia courts, it will use another law sources. So this is a dualistic system, and this dualistic system made very important problems in Ottoman state.
I think in Malaysia we also have the dual system, except that probably the one that we have in Malaysia is a bit more structured. Maybe Prof. Farid would like to respond to that, just in case you want to show the comparison of dualistic system applicable in the Ottoman versus the one that we have here in Malaysia.
Okay. Thank you, Sister Misan. Well, in Malaysia, probably we could say that in Malaysia we have the tri-system because we have the three-court system, the civil court system, the Sharia court system, and then the native court system. And the laws applicable in the three-court system is also different, as mentioned by Dr. Ahmad Kilinc. The sources of law is different, or the applicable law is different. So we may have another program, Dr. Ahmad Kilinc, on how during the Ottoman they have resolved the issue. Then probably Malaysia also could consider that solution.
Yes, you're right. Thank you very much. I hope we can do it again.
Yeah, so that's a hint for another collaboration actually. Okay, now moving on, there's another question. What is the difference between the sources of law of the Ottoman Empire and the Turkey state now? Does the law or precedent back in the Ottoman Empire have validity or major effects on the legal system of Turkey today?
Yes, thank you very much again. The main difference is the statute of the state. The main difference is the statute of the states. You know, while I'm explaining in the Ottoman state, I said that Ottoman law system has two parts. One of them is Islamic law, and the other one is the Sultanic law. But when we come here in Turkey, according to our constitution, we are a secular state. So this is a very important differences. So our sources are not regarded with Islamic law. So this is a very important difference. I think that's gonna be enough.
Okay, this question I think probably would be directed to Prof. Farid. As we all know, just now it was mentioned that in the Majallah, they adopt the Hanafi views. But we also know that the Majallah in Malaysia, we also adopt some part of the Majallah in which we in Malaysia follows the Mazhab Shafi'i. So
Yes.
how does the compromise happen in this situation, Prof? You're muted.
Yeah. If I got it correctly, the question, I suppose the Majallah would mostly refers to the views of the Hanafi. In Malaysia, of course, generally we could say that Shafi'i would be our main reference. But if you look at the process of codification in Malaysia, we have not only referred to the views from Shafi'i's mazhab, we also have referred to the views from other mazhab. So the process of tarjih or the selection is not confined to one mazhab or our main mazhab of mazhab Shafi'i. There's also reference if you look at the Islamic law enactment in Malaysia. There's also reference to other mazhab. So I think if the question is whether we are confined to one mazhab, and the answer will be no, particularly when we refer to the not only the codification, I think in Islamic finance also the views from other mazhab was referred to. So we are not only, of course, in terms of probably to avoid any confusion in the area of the specific ibadah, obligatory ibadah in terms of salah and so on, then probably we are a bit more strict in reference to the Shafi'i mazhab to avoid any confusion. But in other areas, in commerce, for instance, now the best example would be Islamic finance, then we are not confined to mazhab Shafi'i. Thank you.
Wonderful. There is another question directed to Prof. Farid. This is from M. Artut. I hope I pronounce your name correctly. Do you think majallah has the value it deserves in the Islamic world? Can't we get more use out of it?
Okay, thank you about the question. Yeah, I suppose the majallah is one value of the majallah in general. One value of the majallah is the ability of the fiqh to suit, or Islamic law in general, to suit the need of the day. First, before the majallah, I think Dr. Ahmed Kilinc probably can correct me if I'm wrong. Before the majallah, we don't have an example of systemization of the principles in fiqh in one document with easy reference, topical, with numbering and so on, where you can refer to a specific paragraph to arrive at a particular principle. So at that time, I suppose in the age of Tanzimat and so on, you need those things, because you have the examples from the other parts of the world that have more systematic codification of the law. So the majallah shows the ability of the fiqh to answer the needs of the day. I think that would be applicable in any days, that the Sharia or the Islamic law will be able to fulfill the need of the day, because it is the way the Sharia is. The way the Sharia is something that we need to explore and to understand, and with that, then we could see the relevance of the Islamic law and to suit the need of our time. Again, I think most of the participants would be familiar with Islamic finance, so that would be the reason why I refer to Islamic finance, well, because everyone would be familiar with that. Thank you.
Yeah. Okay. So we have a question, but I think I'll just rephrase the question a little bit, because we've heard a lot about how majallah has contributed towards the development of Islamic fiqh. But other than that, other than the majallah, is there any other remarkable contribution of the Ottoman Empire in the development of Islamic law?
Yes, thank you very much, Mrs. Simpson. Yeah, in the development of Islamic law in the Ottoman, I can say that the Ottoman state started the making law in a modern way. Yeah, the majallah is an example. And I have to mention another law act, which is a family law. It was in 1970, and in this family law in 1978 in Ottoman state has all the mazhabs has been used while enacting family law. So, and these laws, majallah, family law, or 1840 criminal law, penal law, we can say that these laws are the examples of the other laws for other Islamic worlds, because they are the first steps of modernizing the law sources. After Ottoman state, so many Islamic countries wants to create a law and in a modern way. So these Islamic states should or may or have to look at the Ottoman state examples. So this is I think, in my opinion, this is an important step for development of Islamic law regarding to Ottoman state.
Wonderful. Thank you so much, Dr. Ahmed. There is another question directed to Prof. Farid. It was mentioned just now that Turkey is a secular state. How about the position and approach in Malaysia?
Okay, thank you for the question. Okay, in Turkey, I suppose Dr. Ahmed Kilinc probably could support me on this. I think in the constitution of Turkey, it clearly states that, that Turkey is a secular state. So that's specific reference, and also that you have 3 or 4 other paragraph or reference in the provision in the constitution of Turkey that emphasize on this and on the secular nature of the Turkish state. And you have several cases where sometimes, because of the secular nature of the state, restriction may be imposed on the freedom, on the liberties of the citizen of Turkey. So that's the emphasis and the explicitness of secularism in Turkey. In Malaysia, you can't find the word secular in the constitution of Malaysia. So in that sense, there is no reason to say that Malaysia is a secular state in the same sense of the Turkish nation state. So, for instance, Dr. Ahmed Kilinc have mentioned that Islamic law is not a source of law in Turkey as a secular state. But in Malaysia, in the constitution of Malaysia, it refers to Islam. And it allows the legislation on Islamic law. So certainly Islamic law is a source of law in Malaysia. So certainly Malaysia is completely different in that perspective from Turkey, where the constitution itself recognizes Islam as a source of law. And certainly the constitution also recognizes the existence of Sharia courts in Malaysia. So that's the position in Malaysia. Not similar to the position of Turkey at present. Thank you.
Yeah, perhaps if you want to discuss more about the Malaysian position, whether Malaysia is an Islamic state or not, that would be another webinar series. Okay, we have one last question from Sister Farahiza Bakri. She's actually our head of department. Is there any hope that the Islamic Khilafah be revived with all those glories which were achieved during the Uthmaniyyah period, especially in implementation of Islamic law? If you believe that this is possible, how Muslim world would realize it? If the answer is no, why? Perhaps Dr. Ahmed can start first, and then after that followed by Prof. Farid.
Mrs. Mizan, thank you very much again. Thank you very much, Fariza Bekri, for your question. Yeah, it is this question, is there, the question starts with, is there any hope? So answer will be, hope is a feeling, answer will gonna be another feeling. We're gonna another feeling. Yeah, is there any hope? I think to answer this question, I think we have to understand the relations with the relations of the Islamic states. So we have to look at the current Islamic states relations. So how can the answer is about to understand how are the relations between the Islamic states? Do you think that all the Islamic states are have a good relationships? I think we cannot say that all the Islamic states has a good relationships in current world. So I think there is no so much hope about this issue because we know that so many Islamic states has so many problems with each other. If they cannot solve these problems, they cannot think about this question.
Prof. Farid, maybe you would like to respond?
Okay, thank you. So what do we mean? Okay, what's the point when we refer to the Khalifa or Islamic Khalifa? What do we want from that? What do we really want from that? Is it a question of unity for Muslim, or is it about the application of Sharia? So if it's about unity, then I think as mentioned by Dr. Ahmed Kilinc, how we could achieve unity? Sometimes it's a question of chicken and egg. Okay, if we have the so-called Islamic Khalifa, therefore we have unity. Or could we have unity first, and we can call that unity in whatever name? Is it Islamic Khalifa, or is it the IOC or OIC or whatever names that you want to put it? So sometimes it's a question chicken and egg. Do I need the Khalifa to exist first, therefore you have unity? Or because of unity, then you can term it in whatever you want, in whatever fashion, but there is unity of Muslim. And about the same also, if you're referring it to as a notion where you have the application of Islam. So of course, Islam is not only about the penal law. Islam also about akhlaq. So are we referring to Khalifa in the sense that in reference to the penal law, but we are forgetting about akhlaq, we are forgetting about the other teaching of Islam, because the teaching of Islam is not only about penal law. Teaching of Islam is also about ihsan, akhlaq, and so on. So I think we have to be clear also when we refer to the caliphate, what we really wish it to achieve, and whether we have to work with what the available resources that we have, the available instruments that we have, the available formats that we have to achieve what is expected from us, not only to look at the format, but to look at the substance. Thank you.
Yeah, I think that's of course it's a challenge in itself to achieve the Islamic Caliphate. If you were to refer to the period of the Khulafa ar-Rashidun, for example, or with all this diversity that we are facing today, probably it's going to be a challenge to achieve that level of Islamic Caliphate, Khilafah. Okay, there's still one final question. I'll try to rephrase this question because this is a quite general question asked here by Fado. All right. So he asks, if a person has knowledge, but because he has no power, his opinion may not be considered. So back then, how did he or if he or she wanted to give their opinion, how was it done during the administration back then? I think this is regarding probably if there were some restrictions in terms of the freedom of opinion. Were there any restrictions given by the caliphs or caliphate or the administration during the Ottoman Empire in terms of the knowledgeable or scholars to give their opinion? Did they face that kind of a situation, Dr. Ahmed? Because we know that in some of the period, there were times where the Muslim scholars were forbidden from giving or from expressing opinions, especially those opinions which were contradicting to the policies of the administration. During the Ottoman Empire, did this also happened, and how was it handled?
Yes, yeah, thank you very much again, Mrs. Mizan. Yeah, I think the question is about freedom of opinion, declaring the opinion. Yes, we can say that. Yeah, I think we have to answer this question in the in what time, in which period we are talking about. This is an important question. If you look at the classical period of Ottoman Empire, the answer will be changed. And if we say that the Tanzimat Edict era or New Ijtihad period, the answer will be changed. In the New Ijtihad period, in Ottoman state, there was a constitution which dated in 1876. In that constitution, the freedom of opinion or the freedom of expressing is written in that constitution. So we have a legal source in the Tanzimat period. In the classical period, we can say that there is not a modern style constitution of Ottoman state. Yes, there is some forbidden about opinion, declaring the opinion. There are some forbiddens in the classical period, but they are all these forbiddens or these forbiddens are all about the structure of the state. Think about it. It is an Islamic state, and one person is want to say bad words about Allah Ta'ala. So this opinion was forbidden in the classical period. Yes, I think that is, yes, thank you.
Thank you so much, Dr. Ahmed, as well as Prof. Farid, for the sharing that we had tonight. And my deepest appreciation goes to all the participants who have been very active in engaging and have been, I think, very active listeners to the webinar that we have tonight, inshallah. With his permission, we'll probably have another series of collaboration in the future, hopefully. And thank you, Tan Sri, for coming back to our webinar. All right. So we I think we received a few messages coming from the participants as well, congratulating the committee, the organizers, for organizing this event. Alhamdulillah, we managed to realize this plan tonight. So as a final conclusion, I think with a 600 years history of development under the Ottoman Empire, we have seen ups and downs within the empire, and we have also seen a period where Islam was stagnant, almost not moving. There was no significant development happen, but later we could also see the period where reformers or mujaddid arose, And I think that goes well with the saying from Abu Hurairah, who narrated a hadith from the Prophet sallallahu alaihi wasallam. Indeed, Allah raises for this ummah every century someone who will revive for her religion. So inshallah, I hope that after tonight's webinar, our young minds that we have here watching us will be inspired and will take aspiration to become the revivers of Islam, inshallah, in this 21st century. But before we end this session, perhaps we can hear a few words from our Dean, Sheikh Murshid bin Qasim, as a closing remark. I would like to welcome Ustaz Murshid.
Terima kasih Sister Mizan. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillah wa syukurillah. We are thankful to Allah Subhanahu wa Taala for His willingness that we managed to successfully organize this webinar, in which initially was just from simple and humble idea of having it in the form of a mass lecture, internal mass lecture. But eventually, alhamdulillah, it becomes an international webinar that involves two leading universities, namely National Islamic University Malaysia and Ankara Yildirim Beyazit University from two different countries, namely Malaysia and Turkey. So what a big opportunity and cooperation, alhamdulillah. It is also really such an honor for me on behalf of the Center for Foundation Studies, IUM, to express my gratitude to our esteemed presenters, Associate Professor Dr. Ahmad Kilinc and Professor Dr. Farid Sufian Shuaib, who have shared with us an insight on the contribution of Khilafah Islamic Uthmaniyyah to the development of fiqh and Islamic law, and also to all participants of the webinar for your presence as well as active participation that make this webinar a great success. And also a special gratitude to Honorable Professor Emeritus Tan Sri Datuk Zulkifli Abdul Razak, Rector IUM, and also Honorable Professor Dr. Jawahir, who has represented Prof. Ibrahim Aidinli, Rector of Ankara Yildirim Beyazit University, to take out time from their busy schedule to attend and to grace the event. Thank you for inspiring and encouraging us with your words of wisdom on this special occasion. A special thanks also to Honorable Professor Dr. Khairi Bogezid, Dean Faculty of Law, Ankara Yildirim Beyazit University, Honorable Professor Dr. Farid Sufian, Dean Ahmad Ibrahim, Kulliyyah of Law, IUM, and also Sister Farahiza Bekri, Head Department of Legal Studies, CFS IIUM, for providing immense support to make the webinar successful. So I must also thank the organizing team, in particular Brother Ridwan, Sister Mizan, Sister Farhana, Sister Badaria, Sister Nina Shazmin, and the rest for working hard for the past few days to make this webinar successful. So I believe this is just a beginning for more fruitful cooperations to come, inshallah. And lastly, congratulate all students and staff for your active participation. Thank you and shukriya to everyone for making this a great success. So with that, aqulu qawli hadha astaghfirullah li wa lakum. Assalamualaikum warahmatullahi wabarakatuh.
Thank you so much, Brother Murshid. Just before we end our session tonight, maybe Dr. Ahmed would like to have last few words.
Thank you very much, Mrs. Mizan. My esteemed rector and my dear deans, distinguished academics and students. I think I must thank to Professor Farid Sufian and International University of Malaysia and Ankara Yildirim Beyazit University, and they're all hardworking staffs. It was very nice for me. I'm very honored to gather with the rector and with the deans of the International University of Malaysia and our students. I think this webinar would useful and fruitful for both for academics and for students. I think and I hope this is going to be the beginning of these academic relations. I hope we can see each other in the other webinars or in other international academic activities. Thank you very much. Assalamu alaikum wa rahmatullah.
Well, thank you so much, Dr. Ahmad. We still get all those messages chatting in the chat box. Alhamdulillah, they are communicating. Hopefully one day we can have some probably physical student exchange where we can, you know, have the exchange not just on knowledge, but also I think the culture, the heritage of these two different countries. Just before we end, Tan Sri, would you like to say something, Tan Sri?
Okay, this is my worry when I come back, you know. But I just want to say something out of interest. I think it's time if we can develop common courses between Ankara University and IIUM so that this thing could be shared in a more regular and a systematic way. Otherwise, it becomes very episodic. After this, we will forget about it. Whereas this is something which is, I think, on a continuum that we need to follow through what the Ottoman Caliphate has been doing. It is not a full stop. How can we revive it? How can we build it? Not only in Turkey, inshallah, in Malaysia as well. So if we can do this on that kind of a basis, maybe we have something else to look forward to beyond just this seminar. But anyway, I would like to thank you very much. I missed a lot, I'm sure. But the other side is also very fascinating. When a Christian talk about the humanity of the Prophet sallallahu alaihi wasallam, is another ball game altogether, inshallah. So thank you very much. Send my regards to your rector. Hope to see him one of these days, either in Turkey or in Malaysia. Assalamu alaikum.
Thank you so much, Tan Sri. Inshallah, we'll take note of the request. Prof Farid lah kena take. Okay, but inshallah you can still follow the discussion from the YouTube channel. It's live on, it's available on the YouTube channel, Department of Legal Studies YouTube channel, inshallah. And we can also later on watch the interesting and I'm sure a very critical discussion on the other side, on the Christians' view of the. I missed that one as well. So. With that, I would like to once again thank you everybody for your participation, cooperation, collaboration. May Allah bless all of us and protect us. We still have to fight this COVID-19. It's still not ending. On top of that, we also need to fight the climate change. Greta Thunberg is doing her part. What are we doing here? What's our part? Then probably we need to ask that as well. So with that, I would like to end our session tonight with Tashakudarum. Thank you so much. Terima kasih. Assalamualaikum warahmatullahi wabarakatuh. Thank you.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, everyone. Thank you,
Thank you very much.
Dr. Harry.
Thank you very much.
Thank you very much. See you again.
Thank you. Thank you very much, Prof.
Assalamualaikum.
Salam. Terima kasihlah doktor, tunggu
Terima
sampai habis.
kasih banyak Syed. Nanti kita pergi Kelantan, kita belanja.
InsyaAllah. Ya, Assalamualaikum. Saya
Okay,
end
ya, thank you so much.
Terima kasih